Before opening the bare act, imagine you want to file a civil suit. Ask yourself, where does a civil suit actually begin? Not in the courtroom, not before a judge. It begins when someone decides, my legal right has been violated, and I want the court's help. The CPC is written in the same chronological order as a real lawsuit. It doesn't randomly jump from topic to topic. It follows the life of a civil suit from birth to conclusion. Step 1. Section 26. Read the heading first. Section 26. Institution of suits. Even before reading the provision, ask, what does institution mean? In ordinary English, institution equals beginning or commencement. So immediately you know. This section tells me how a civil suit begins. Now read section 26 slowly. The first line says, every suit shall be instituted by the presentation of a plaint. Let's stop here. Every single word matters. Every suit, no matter whether it's recovery of money, property dispute, partition, injunction, declaration, specific performance. Every civil suit starts in the same basic way. Shall. Lawyers love this word. Shall usually means mandatory, not optional, not maybe. The CPC is telling you, if you want to start a civil suit, this is the compulsory method. Instituted. Again, this simply means commenced or started. Presentation. Notice, it does not say writing or drafting. It says presentation, because the plaint must actually be filed before the competent court. Only then does the suit legally begin. Plaint. Now ask another question. What is a plaint? Think of it as the plaintiff's official story. It contains who the parties are, what happened, which right was violated, what relief is sought. Without a plaint, there is no civil suit. Now ask yourself, if section 26 only tells me, start by presenting a plaint, then naturally, my next question is, what exactly is a plaint? The section doesn't answer that. So where do we go? To the orders. Why is order I next? Before writing anything, the court needs to know, who are the people involved? Imagine filing a case saying, someone cheated me. The judge asks, who? Exactly. That's why the CPC first talks about Order I, parties to suits. Because without parties, there cannot be a suit. Order I. Read its title carefully. Parties to suits. Not evidence. Not witnesses. Not documents. The very first concern is, who is suing? And, who is being sued? Rule 1. Who may be joined as plaintiffs? Suppose A and B jointly own land. Someone illegally occupies it. Can both file one suit? Yes. Rule 1 explains when multiple plaintiffs can join together. Rule 3. Now think from the opposite side. Suppose 3 people together damaged your property. Can all 3 be sued in one case? Yes. If the right conditions exist. Rule 3 explains that. Rule 9. Now imagine you accidentally forgot to include one person. Does the entire suit automatically fail? Usually, no. Rule 9 says, a suit shall not fail merely because of misjoinder or non-joinder of parties, except where a necessary party is missing. This rule prevents technical mistakes from defeating justice. Rule 10. Sometimes, months later, the judge realizes another person must be added, or someone has been wrongly included. Can the court correct this? Yes. Rule 10 gives the court power to add, remove, or substitute parties. Why does order I come before everything else? Ask yourself, can the court hear evidence without knowing who the plaintiff is? Impossible. Can it grant relief without knowing who the defendant is? Again, impossible. So order I naturally comes first. Why is section 26 written beside order I? Now comes the important understanding. Strictly speaking, section 26 doesn't mention order I. But think practically. Section 26 says, a suit begins. Immediately after a suit begins, the first procedural question becomes, who are the parties? Therefore, order I is the first procedural step flowing from section 26. That's why you link them. Order 2. Now you've identified the parties. Next question. Can the plaintiff file 10 different suits over the same dispute? No. The law discourages unnecessary multiplicity of litigation. So Order 2 deals with how the suit itself should be framed. Rule 2. This is one of the most important rules in the CPC. Suppose Rahul lends 5 Indian rupees lakh to Mohan. Mohan doesn't repay. Rahul files a suit only for 2 Indian rupees lakh. Later, he files another suit for the remaining 3 Indian rupees lakh. Can he? Generally, no. Rule 2 requires the plaintiff to include the whole claim arising from the same cause of action in one suit. This avoids repeated litigation over the same dispute. Rule 3. Sometimes a plaintiff has multiple causes of action against the same defendant. For example, a dispute involves both breach of contract and recovery of money. Rule 3 permits the joinder of causes of action in appropriate cases, promoting efficiency and reducing the need for multiple suits. Why is Order 2 linked to Section 26? Section 26 tells you a suit is instituted by presenting a plaint. Once you decide to institute that suit, the next practical question is, how should I frame my claim? Order 2 answers that question. So it logically follows Section 26. Order 3. Now imagine you're ill, abroad, or a company filing a suit. Must you always appear personally? Not necessarily. That's why the CPC provides Order 3, recognized agents and pleaders. It explains who may appear, act, or plead on behalf of a party, such as an advocate or a duly authorized agent. Rule 1. A party may appear in person or through a recognized agent or pleader where permitted by law. This makes the legal process practical and accessible. Rule 4. This rule deals with the appointment of a pleader. In practice, it is connected with the vakalatnama, through which an advocate is authorized to act for the client. Without proper authority, an advocate cannot represent a party. Why is there no section? Notice the dash. This is because there is no separate section in the CPC that specifically introduces Order 3. The code sometimes places procedural matters directly in an order without a corresponding section. So leaving it blank is correct and shows that you did not force a connection where none exists. Order 4. You've identified the parties, decided how to frame the suit, and arranged representation if needed. Now comes the formal step. Actually instituting the suit before the court. Order 4 tells you the procedural requirements for the institution of suits. Rule 1. Every suit shall be instituted by presenting a plaint to the court or to an officer appointed by the court. This complements Section 26 by explaining the procedural act of filing. Rule 2. The court registers the plaint if it complies with the prescribed requirements. Registration gives the suit its official identity and allows the judicial process to move forward. The flow so far. Think of it as a story. Section 26. A civil suit begins by presenting a plaint. Order I. Identify the parties to the suit. Order 2. Frame the suit properly and include the appropriate claims. Order 3. Decide who will represent the parties. Order 4. Formally file and register the suit. Notice how each step naturally leads to the next. That's the beauty of the CPC. It isn't just a collection of provisions, it's a procedural roadmap for the entire life of a civil suit. If you study each order by asking, what practical problem is this solving at this stage of the suit, you'll start reading the BARE Act like a lawyer rather than memorizing it like a textbook. That's exactly the approach most senior advocates appreciate. Where were we? By the end of Order 4, the plaint has been filed and the suit has been registered. Now ask yourself, can the judge immediately start hearing the case? No. Why? Because the defendant doesn't even know a case has been filed. One of the most fundamental principles of natural justice is, no person should be condemned unheard. Audi ultram partem. So the court's first duty after registering the suit is to inform the defendant. Sections 27-29 read the heading. Section 27. Summons to defendants. Before reading the section, ask yourself, what is a summons? Many people think a summons is a punishment. It isn't. A summons is simply an official notice issued by the court informing a person that a case has been filed against them and directing them to appear before the court. It protects the defendant's right to be heard. Section 27. It says that once the suit is duly instituted, a summons may be issued to the defendant to appear and answer the claim. Notice the sequence. The CPC first says, file the suit, Section 26, register it, Order 4. Then notify the defendant, Section 27. The defendant cannot defend a case they know nothing about. Section 28. Now ask another question. What if the defendant lives outside the jurisdiction of the court? Suppose a suit is filed in Kolkata, but the defendant lives in Delhi. Can the Kolkata court still send a summons? Yes. Section 28 explains how summons may be sent for service outside the local jurisdiction of the court. It ensures that geographical distance does not prevent justice. Section 29. What if the defendant is in another state and the summons needs assistance from another court? Section 29 deals with service of summons through courts in other jurisdictions, enabling cooperation between courts. Again, The objective is simple. Every defendant must receive proper notice before the case proceeds. Why are sections 27 to 29 linked with Order V? The sections establish the legal authority to issue and serve summons. But they do not explain how summons are actually served. That procedure is found in Order V. Think of it this way. Sections 27 to 29. The court has the power and duty to issue summons, Order V. Here is the detailed method for serving those summons, Order V, issue and service of summons. Read the title carefully. There are two distinct stages. Issue, the court prepares and issues the summons. Service, the summons is delivered to the defendant. Both stages are equally important. A summons issued but never served is useless. Rule 1. This is the starting point. Once the suit is instituted, the court issues a summons requiring the defendant to appear and answer the claim. Without this rule, the defendant would never officially become part of the proceedings. Rule 9. Now think practically. How is a summons actually delivered? Rule 9 permits service through recognized modes such as court offices, approved courier services, registered post, speed post, or electronic means where permitted by law. The CPC has evolved to make service faster and more reliable. Rule 17. Now imagine this situation. The process server goes to the defendant's house. The defendant deliberately hides inside or refuses to accept the summons. Can the defendant escape the lawsuit simply by refusing to open the door? No. Rule 17 allows the process server, after following the prescribed procedure, to affix a copy of the summons at a conspicuous part of the defendant's residence. The law does not permit someone to defeat justice by evading service. Rule 20. Suppose even Rule 17 doesn't work. The defendant cannot be traced despite reasonable efforts. Should the case stop forever? No. Rule 20 empowers the court to order substituted service. This may include publication in a newspaper or any other mode the court considers appropriate. The idea is that if ordinary service is impossible, another reasonable method should be used to notify the defendant. The flow so far: the plaintiff files the suit, the court registers it, the court issues summons, the summons is served, the defendant is given an opportunity to appear. Only then can the court proceed further. Order 6. Pleadings generally. Notice there's no section linked to Order 6. That is because the CPC directly lays down the general principles of pleadings in this order without introducing them through a separate section. What is a pleading? Ask yourself. How does the court know what each party is claiming? Not through oral arguments at first. The court learns this from the pleadings. Pleadings are the formal written statements filed by the parties. They define the scope of the dispute. In a civil suit, the pleadings are generally the plaint and the written statement. Rule 2. This rule is one of the most important in the CPC. It says that pleadings should contain material facts, not evidence. This distinction is crucial. Suppose you're suing for breach of contract. A material fact is, the defendant entered into a contract on the 1st of January, 2025 and failed to perform it. The actual contract document or witness testimony is evidence, not a pleading. Think of it this way. Material facts tell the court what happened. Evidence proves that those facts are true. The pleadings are meant to define the issues, not prove them. Rule 17. Sometimes, after filing the plaint or written statement, a party discovers an error or needs to add an important fact. Can the pleading be changed? Yes, but only with the court's permission. Rule 17 deals with the amendment of pleadings. The court allows amendments when they are necessary for deciding the real controversy, while also ensuring that the opposite party is not unfairly prejudiced. Order 7. Plaint. Now ask. If Order 6 explains what pleadings are generally, where do we learn about the plaint specifically? The answer is Order 7. This is why it is linked to Section 26, because Section 26 tells us that every suit begins by presenting a plaint. Order 7 then explains what that plaint must contain and what happens if it is defective. Rule 1. This rule specifies the essential particulars of a plaint, including the name of the court, the names and addresses of the parties, the facts constituting the cause of action, the relief claimed, and other necessary particulars. Think of Rule 1 as the blueprint for drafting a proper plaint. Rule 10. Suppose a plaint is filed in the wrong court. Should the judge dismiss it immediately? No. Rule 10 allows the court to return the plaint so that it may be presented before the proper court having jurisdiction. This avoids unnecessary hardship to the plaintiff. Rule 11. Now imagine the plaint is fundamentally defective. For example, it discloses no cause of action, the suit is barred by law on the face of the plaint, or the required court fee is not paid despite an opportunity. In such situations, the court may reject the plaint under Rule 11. This is different from dismissal after trial. The court is saying that the plaint itself cannot proceed in its present form. Order 8, written statement, set-off and counterclaim. Now the defendant has received the summons. Ask yourself, how does the defendant answer the allegations? Through a written statement. This is the defendant's formal written defense. Rule 1. The defendant is required to file the written statement within the time prescribed by law. The purpose is to ensure that litigation proceeds efficiently without unnecessary delay. Rule 6. Set-off. Imagine the plaintiff sues the defendant for rupee 1,000,000. The defendant says, "Yes, but the plaintiff also owes me 40,000 Indian rupees." Instead of filing a separate suit, the defendant may claim a set-off, reducing the amount payable if the legal requirements are satisfied. Rule 6a. Counterclaim. A counterclaim goes even further. The defendant may not merely defend the suit but may also bring an independent claim against the plaintiff in the same proceedings. For example, the plaintiff sues for recovery of money. The defendant alleges that the plaintiff breached a contract and claims damages. Rather than filing a fresh suit, the defendant may raise a counterclaim. This saves time, reduces costs, and allows the court to resolve all connected disputes in one proceeding. The story so far. Notice how beautifully the CPC flows. Section 26 and Order 4, the suit begins. Sections 27 to 29 and Order V, the defendant is informed through summons. Order 6, the law explains what pleadings should contain. Order 7, the plaintiff files a properly drafted plaint. Order 8, the defendant responds through a written statement and, where appropriate, raises a set-off or counterclaim. Once both parties have placed their respective cases before the court through pleadings, the foundation of the suit is complete. The next stage of the CPC is about identifying the real points of dispute and preparing the case for trial. That's where the subsequent orders begin to take over. The story so far. By now, have you checkmarked the plaintiff has filed the plaint? Have you checkmarked the defendant has received summons? Have you checkmarked the defendant has filed the written statement? Now the judge has two completely different stories. The plaintiff says, the defendant breached the contract. The defendant says, no, the plaintiff himself breached it. The judge cannot simply start passing a decree. First, the judge must understand. What is the actual dispute? That is where Section 30 begins. Section 30. Read the heading first. Power to order discovery and the like. Notice something. It doesn't say, discovery only. It says, and the like. That means Section 30 is giving the court general procedural powers to prepare the case properly before trial. Think of Section 30 as giving the judge a toolbox. Inside that toolbox are powers to examine parties, order discovery, inspect documents, receive affidavits, call witnesses, require production of documents. Instead of repeating these powers in every section, the CPC says, here are the powers. Then the orders explain how to use them. That is why one section supports many orders. Order X examination of parties. Now ask yourself, the plaintiff and defendant have both filed pleadings. Should the judge blindly believe whatever is written? No. The judge first wants clarity. So Order X begins. Rule 1. The court identifies what each party admits and what each party denies. Suppose plaintiff says, I sold my house. Defendant says, yes. No dispute. The judge doesn't waste time proving that. But plaintiff says, you never paid. Defendant says, I already paid. Now there is a dispute. Order X helps separate facts that are admitted from facts that are disputed. This saves enormous judicial time. Rule 2. Sometimes the pleadings are vague. The judge may ask questions, not to cross-examine, simply to clarify. Example, judge asks, when exactly was this agreement signed? Or, did you actually receive possession? These answers help the judge understand the controversy. Why linked with Section 30? Because examining parties is one of the procedural powers given under Section 30. Section 30 gives the power. Order X explains the method. Order XI discovery and inspection. Now imagine this. The plaintiff says, I have emails proving everything. The defendant says, I have invoices proving payment. Neither side wants to show them. Should the trial become a game of surprises? No. Justice requires openness. That is why Order 11 exists. What is discovery? Discovery means revealing information or documents relevant to the case. The court says, you cannot hide important evidence. Rule 1. One party may ask the court for permission to deliver interrogatories. What are interrogatories? Simply written questions, which the opposite party must answer on oath. Think of them as a written interview before trial. Rule 12. Discovery of documents. The court can direct. Tell the court what relevant documents you possess. Notice, it doesn't yet say, produce them. It first says, disclose that they exist. Rule 21. Suppose a party refuses to answer, to disclose, or to obey discovery orders. Can they ignore the court? No. Rule 21 gives serious consequences. The court may dismiss the plaintiff's suit, or strike out the defendant's defense. Why? Because justice cannot function if parties hide evidence. Why Section 30? Discovery is specifically one of the powers mentioned in Section 30. Therefore, Order 11 naturally follows it. Order XII admissions. Notice, no section. Because the order itself explains the procedure. Ask yourself, suppose both parties agree that the agreement was signed. Why waste time proving it? The law doesn't require proof of admitted facts. That is the beauty of Order 12. Rule 1. Either party may give notice, calling upon the other party to admit documents or facts. If admitted, those facts need not be proved. Rule 6. This is one of the strongest rules. If admissions clearly establish the plaintiff's case, the court may pronounce judgment without waiting for the full trial. Think about how much judicial time this saves. Order XII production, impounding and return of documents. Now ask yourself, discovery only tells us what documents exist. Now what? Bring them before the court. That is Order 13. Rule 1. Documents relied upon must be produced at the appropriate stage. The judge cannot decide without seeing the evidence. Rule 10. Sometimes, documents are returned after they are no longer needed. The court regulates that process. The court also has powers regarding impounding documents when necessary. Why Section 30? Because production of documents is one of the procedural powers under Section 30. Order XIV settlement of issues. This is one of the most beautiful orders in the CPC. Ask yourself, suppose plaintiff writes 10 pages, defendant writes 15 pages. Will the judge decide every sentence? No. The judge asks, what exactly do you disagree about? Those become issues. Example, no dispute. Agreement signed. Issue, no. Both admit it. Dispute, was payment made? Issue, dispute, was there fraud? Issue, the judge frames only these real questions. Everything else is unnecessary. Rule 1. Defines what an issue is. Issues arise when one party affirms a fact and the other denies it. Rule 2. The court distinguishes issues of law from issues of fact. Sometimes, a legal issue alone can dispose of the entire suit. Why Section 30? Because framing issues requires examining pleadings, documents, and parties, all part of the court's procedural powers. Order XV disposal of suit at first hearing. Notice, no section. Now imagine, both parties appear. Everything is admitted. Nothing remains to be tried. Should the court spend 3 years conducting evidence? No. Order 15 says, if there is nothing left to investigate, the court may dispose of the suit at the first hearing itself. Justice delayed is justice denied. Rule 1. Allows disposal where no material question remains for trial. Order XVI summoning and attendance of witnesses. Now, the issues are framed. Evidence must begin. But witnesses don't automatically appear. Someone has to call them. Section 31. Section 31 empowers the court regarding summons to witnesses. Together with Section 30, it forms the basis of Order 16. Rule 1. A party files a list of witnesses and requests summons. Rule 10. Suppose the witness ignores the summons. Can the court do nothing? No. The court can compel attendance through coercive measures permitted by law. Otherwise, no one would obey court summons. Order XVI adjournments. This order looks small, but it is extremely important. Why? Because unnecessary adjournments are one of the biggest reasons civil cases take years. Section 35B. Section 35B allows costs for causing delay. Suppose A party seeks unnecessary adjournments repeatedly. The court may impose costs. This discourages delay. Rule 1. Adjournments should be granted only for sufficient cause. The court must balance fairness with speedy justice. Order XVI hearing of suit and examination of witnesses. Now, the real trial begins. Witnesses enter. Evidence is recorded. Cross-examination takes place. This is the stage most people imagine when they think of a courtroom. Rule 4. Examination in chief is generally given by affidavit. This speeds up the trial. Cross-examination and re-examination then take place before the court. Rule 17. Sometimes, after a witness has been examined, the judge feels something remains unclear. The court may recall the witness to ask further questions. This power exists to clarify doubts, not to allow parties to endlessly improve their cases. Why Section 30? Because recording evidence is another procedural power of the court. Order XIX affidavits. Ask yourself, must every fact always be proved by calling a witness into court? Not necessarily. For certain matters, the court may allow proof by affidavit. An affidavit is a written statement of facts made on oath or affirmation. It saves time where oral evidence is unnecessary or where the law permits this mode of proof. Rule 1. The court may order that particular facts be proved by affidavit. This is especially useful for formal or less disputed matters. Rule 2. Even when evidence is given by affidavit, the court may direct that the person who swore the affidavit appear for cross-examination if justice requires it. This ensures that affidavits cannot be used to avoid scrutiny. The complete flow, Orders X19. Now step back and look at the entire journey. Order X. The judge identifies what is admitted and what is disputed. Order 11. The parties disclose relevant information and documents. Order 12. Facts that are admitted need not be proved. Order 13. Relevant documents are produced before the court. Order 14. The judge frames the real issues for trial. Order 15. If there is nothing left to try, the suit may be decided immediately. Order 16. Witnesses are summoned to testify. Order 17. Adjournments are regulated to prevent delay. Order 18. The trial proceeds with evidence and examination of witnesses. Order 19. Where appropriate, facts may be proved by affidavits. This is why I often say the CPC is less like a list of legal provisions and more like the screenplay of a civil suit. If you keep asking yourself, what would the judge do next? You'll find that each order follows naturally from the previous one. That mindset is what makes it feel as though you've truly studied the bare act rather than memorized isolated provisions.